Recording in progress. A very good evening to everyone present here. On behalf of LawInternships, I, Riddhi Chandal, COO, take this grand opportunity to moderate today's webinar. Firstly, I would like to welcome the team of LawInternships. LawInternships is an online law school and recognized startup by Startup India and Government of India, which extensively provides educational services. LawInternships provides opportunities in the field of law to the students pursuing undergraduate or postgraduate programs such as internships, certificate courses, training programs, publication services, law school kit, and organized events at national level for gaining professional experience as well as improving legal skills while they are being enrolled in a full-time law program. The objective behind this online law school is to provide a credible platform for the law students to fulfill educational requirements by imparting practical exposure and relevant skills. I feel immense proud to share that in past 3 years, more than 2.5 lakh members, including law students, law firms, law universities, advocates, have joined us from Pan India with us. Now, I would like to welcome our eminent guest speaker, Mr. Vivekanand. Sir has completed his education from Central Law College, Salem. Sir is a real estate litigation and intellectual property partner in the Chennai office of INDUSLAW, a multi-specialty Indian law firm that advises a wide range of international and domestic clients. Prior to his joining INDUSLAW, Sir started his career with Mr. B. Ramamurthy and practiced in Madras High Court, Chennai City Civil Court, statutory tribunals, and arbitral tribunals. Thereafter, he joined AZB and Partner as an associate and ASLF Law Offices as a partner. Sir also specializes in due diligence of title to property, property documentation, conveyancing, stamp duty, registration, RERA, and litigation. We are so glad to have you with us, sir.
Thank you.
In today's session, we would be dealing with the following topics. What are the types of real estate contracts? Key aspects to be taken care in the real estate contract, impact of RERA in the real estate contract, interplay between real estate contracts and other laws as to the applicability to the real estate contracts. So before moving further with the session, I would like to brief the instructions to the participants. You're requested to keep your mic off and video on while the speaker is speaking. And if you have any queries, you can raise your hand or write your queries in the chat box, and we will conduct a 15-minute Q&A round at the end of the session. So now, without delaying any further, I would take the pleasure to request Mr. Vivekanand to enlighten us with his profound knowledge. Over to you, sir.
Thanks, Riddhi. I first thank Law Internship for giving me this wonderful opportunity. And it is really nostalgic to be with the students, and it is very, very pleasure of mine to be part of this presentation. I'll just screen share for all the benefit. See, the topic is on the real estate contracts, and we have 4 topics on what are the types of real estate contract, what are the important enactments which hold the field of real estate contracts and which have impact on the real estate contracts, and the statutory provisions of the respective enactments and the regulatory provisions which has an impact in the real estate contracts. Besides that, there is a recent law which is hardly 5-7 years old, called the Real Estate Regulation Act, which is the first of its nature to regulate the field of real estate. So what is the impact of that RERA in the real estate contracts is what we are going to cover. So first we will go to the types of real estate. First I'll introduce what is real estate. So the word real estate is inclusive of both land and building. And when I say land and building, the land is holding or capable of being developed into a building in the land. So that is real estate. An agricultural land or a non-residential or non-commercial use of land which is used for somewhere cannot form part of real estate. It is only a building which is put to different types of uses will form part of real estate. And of course, the building can be used for various legal provision, legal uses such as commercial use, warehousing, industries, residential, or any other, now the concepts of co-living, co-working, everything. So that is real estate actually. And the real estate laws or the real estate contracts precisely have different types of transactions. For example, acquisition, leasing, easementary right, licenses, and a joint venture where two people join together for development of a particular ownership of the land. All those things are the types of real estate contracts which are governed by various real estate laws. The recent enactment, as I said, were twofold. Two statutes were recently enacted. Of course, some states are yet to enact rent control laws. In Tamil Nadu and other parts of some parts of India, the rent control laws have been also enacted, superseding the existing rent control laws, which is more of neutralizing the rights of earlier. The rent control laws were on the protection of tenants' rights, and now they have neutralized to say that it protects both tenant and the landlords. And there is a proposal for enacting a centralized rent control laws also. So these are the laws which have, and the Real Estate Regulation Act, which I said earlier, have impact on the real estate contracts. So that is why I am referring to these provisions of law. The next one is real estate contracts are more on contractual in nature than which has a statutory or rights or obligations created under. There are some statutory rights and obligations created, but substantially the real estate contracts are contractual in nature. It has to satisfy certain provisions of real estate, but it ipso facto it doesn't allow you or create by itself a rights or obligations under the act, except for regulating or restricting certain to be reasonable on the conduct of the parties. The real estate contracts are always contractual in nature rather than flowing from any substantiate statutory provisions. That is the reason why the fundamental right of property has been shifted by a constitutional amendment to a constitutional right under Article 300A, where the fundamental right of the citizens to hold or to enjoy a property has been taken away and has been shifted to a constitutional right where the government can regulate and restrict or acquire the rights in the property by way of an under the enactment or under the statutory provision, which is under 300A. So now coming to the types of contracts. The types of contracts, I would say we can broadly classify into 4 or 5 classifications. One is agreements, one is transfer by itself, the other one are transfer of title is the second part, transfer of right and interest without title is the third part, executory contracts are the fourth part, agency contracts are the fifth part. So I have classified into 5 broad principles of what are the types of contracts for easy understanding and for easy applicability also. So first, coming to the agreement to transfer, the transfer of title, right, or interest, as the case may be, is agreed to be transferred in a future date on particular obligations or conditions fulfilled by either of the contracting parties. So there's as such there is no transfer of title or interest, but an actionable claim right is created in favor of the beneficiary under the contract. So this will form this cannot by itself create any interest in the property, but the person for whose benefit the contract is made on his compliance of his obligation will have a right to enforce the contract and make it enforceable against the party who is in the breach. So there is no, but it will also have all the ingredients of a contract which is under the Indian Contract Act. Like it should be for a valid consideration, valid objective, valid parties to the contract should be competent to enter into with full age or with sound mind. All those increments of Indian Contract Act, which we will see it in the next slide, will be applicable to all the 5 types of the contracts. So here, this agreement of transfer is only a agreement to transfer whatever title or right or interest in a near future based on some agreement between the parties based on some contingencies. Next, coming to the transfer of title. Contracts that transfer of title in immovable property in presentee are maybe of various types like sale deeds, gift deeds, exchange, assignment from government, etc. So here the transfer of the title or the title is conveyed in presentee under the instrument, and the purchaser or the beneficiary gets the title to the property in presentee. And in presentee has been interpreted by various pros that the instrument by itself transfers the title. So there's no further action required. Unlike in agreement of transfer, there will be a subsequent documentation transferring the title as the second type of contract. So this is in presentee. And the third type is transfer of rights and interest alone. Here, there may not be a transfer of title. See, transfer is defined in section 5 of the Transfer of Property Act, which I will, in the subsequent provisions, I will detail it. So the transfer of interest or right is like mortgage deeds, lease deeds, easement or leasement agreement. In fact, to some extent, agency where the agency is coupled with interest. And there are instances where there is a right of first refusal. So these are the right or interest which is transferred to a particular person, of course, subject to fulfillment of a contingency or a qualification, what is agreed under the respective contracts. So this is one type of a right where the title is vested with the original owner, but the original owner creates a right in favor of third party only for a limited purpose without affecting his title. Maybe that may be an encumbrance in the property, but it will not affect his title, and it is always capable of being terminated or this. Then the executory contracts. Executory contracts are contracts like construction agreement or some service providing under the, see, for example, in large townships, there are maintenance agreements executed by in favor of the maintenance agency. The associations may appoint agencies. So these are the executory contracts where neither right is created, transferred, nor title is transferred, but they have a monetary consideration for services rendered in the contract. Why this is coming under the real estate contract is the maintenance of a building and the land is part of a real estate work. So substantially, the developers appoint maintenance agencies, appoint vendors, appoint contractors for development or those things. So since it's related to land and building, it is substantially coming within the purview of real estate contracts. The next one is normal agency, where it is covered under contracts, chapter 10 of the Contract Act and Power of Attorney Act 1882. So agency can be coupled with interest, with consideration, depending upon the contract between the parties. And they can also be a simple related party agencies, just to take care in the absence of a person. Or see, there are types of agencies can be classified into a way which is covered under section 182 to 238 of the Contract Act, which I'm not detailing because it is by itself a separate chapter which we have to deal with. So now the agency are like, it may be with interest, coupled with interest, with consideration, where coupled with interest and consideration are not capable of unilaterally cancelling. There is a procedure to follow for cancellation or revocation or termination of the agency. As such, as regards the normal related party or a normal agency, a simpliciter agency can be terminated by the principal at any time. So these are the types of agencies which is covered under, and agency normally gets terminated, automatically terminated at expiry of the, if the principals are individuals or family of members, it automatically gets terminated on death of particular persons. So that is a type of contract which you have to take care, or which you have to have it in mind before we look at the structuring of the contracts, where at what time there is there an termination by operation of law. All those things we will have to take care in the agency part. The important enactments now coming to which may have, or which are directly and indirectly associated with real estate contracts, are first and foremost is the Transfer of Property Act. And the Transfer of Property Act is the constitution for real estate laws or real estate contracts, which is well enacted and which is still holding the field, and which gives you solution for various discrepancies or various roadblocks. Next is the succession laws. See, Transfer of Property Act deals with voluntary transfer between the parties. As regards succession laws are concerned, they are substantially by operation of law. Of course, exception would be testamentary succession, where the disposition is changed by the testator voluntarily, but still it will be an operation of law, because the will or the testament, whatever is made by the testator, will come into operation by effect of the succession laws. So these succession laws are operation of law. We normally call it as an operation of law, where the title or the right or interest is transferred by operation of law, which is succession laws. As regards the right settlement laws and standing orders are concerned, they differ from state to state, but post-British, post-independence or British rule, we have enacted in various states the pari materia same laws, and the rights or the title is conferred or assigned by the government based on the qualifications of a particular person on certain criteria, where once he gets qualified, title is transferred or assigned to the persons. Of course, the next is Registration Act is a regulatory act to make public aware that this particular land, this transactions have happened, and this is the owner at the present, or this is the encumbrances which is affecting the title, marketability of the title, or it is a regulatory act to make the public aware that what are the transactions with particular land is happened. Of course, a Stamp Act is a fiscal enactment where the taxation, it's an indirect taxation on the transactions or the instruments which is executed between the parties for making the document valid, and it's a fiscal, it's a type of indirect tax. Easement and licenses, as we said, there is no title transfer, but a right or interest is created in the, for example, licenses, it is only the interest created. Whereas easement, there is a right created because you have a right to enforce it. License is always a limited, is lesser than little easement or lease. The difference would be that license, it's only right of enjoyment, where the possession is not parted away, or there is no exclusive right or created in the land. As like easement, though the title is not transferred, but still there is an exclusive right of enjoyment of a particular easement, be it a air, be it a water, be it a pathway access. See, there are various types of easements where it may be for air, water, access, or whatever it may be. So that is will fall under easements and licenses. As I said, Indian Contract Act, all the contracts, be it the 5 type of contracts which I was talking about, will be covered within the provisions of Indian Contract Act, and it has to be qualifying all the provisions or all the compliances of Indian Contract Act. All the 5 types of contracts which I was earlier talking about should satisfy the ingredients of a valid contract. Like the person should be very competent to enter into a contract. He should have attained majority. He should be in sound mind. He should not be coerced or undue influence. Should not, all those this thing. The consideration should be valid. the consideration, the objective of the contract should be legal, and it should not be for any illegal or immoral purpose. All those ingredients have to be satisfied for all the 5 types of contract to enforce or to be binding on the parties. The specific relief act next would be that it is the enforcement of the contract. It is more on the enforcement when there's a dispute arising, or what are the qualifications to disqualify a person from enforcement. That's the specific relief act. Of course, limitation act, there is a huge difference between other remedies and the remedy against the immovable property. Limitation act, it is the principle, the normal principle of limitation act is that when a claim is, or when a right is time barred, the normal principle is the right to seek remedy is barred, but the right to the claim is not extinguished. But with regard to under section 27 of the limitation act, the right to claim to any immovable property post limitation period extinguishes, which I will detail when I come to the statutory provisions of limitation act. So that is the limitation act, where you cannot claim for a particular property or challenge any contract relating to real estate after a particular time once the limitation gets over. Of course, now Real Estate Regulatory Act is the regulatory act to ensure that the customers are delivered with the product which is promised by the promoter in time with quality and is maintained as per the contract. So that is all. Land acquisitions are the laws, which is compulsory acquisitions, which now, in view of the recent 2013 Act of new Act, the provisions of acquisitions have substantially changed, and the governments now prefer to have more private treaty acquisition than compulsory acquisition. So land acquisitions are acquisition of land in against the right or interest of the party, which is involuntary, but it should comply with the provisions of 300A as well as the relevant. There are various land acquisition laws. Besides 2013, we have National Highways Act, State Highways Act, and many of the industrial development laws in each state provides for land acquisition. For example, Town and Country Planning Act provides for land acquisition. So land acquisitions are the laws which makes you to compulsorily acquire lands, and which now over a period of time it has been started acquiring. The agencies or the statutory party bodies have started acquiring through a private treaty, which will also be part of the real estate contract. Then the land reform enactments are more on the ceiling limit, which is now applicable only to the agricultural land. In I think urban ceiling have been overall all over India have been abolished, and land reform ceiling acts are applicable only for the agricultural land. And of course, there also they have an acquisition procedure and acquisition act where the ceiling, the excess land, if at all found to be in possession of a person, they can acquire it by a procedure contemplated and pay a compensation. So these are, and it can be by way of a private contract or by way of operation of law. Of course, the other part, debt recovery laws, rent control, debt recovery laws, and are laws which is more on enforcement provision, and Town and Country Planning Act, Benami Transaction Act, or more on regulatory procedure of the contracts. See, for example, a person cannot enter into a contract for the benefit of a third party, and he cannot. So those are the laws. And rent control legislation is that you have to now comply with lot of procedure once you enter into a real estate contract relating to a rent, lease, or in example, Tamil Nadu, we have a lot of procedure once you enter into a lease or this. So these are more on the regulatory part. And local laws, some of the local laws also cover the development of a building or the contracts relating to development of the building. So each state may have vary from on the local laws. So I've just made it to have it in the back of the mind that these are the laws which we need to take care when we frame a real estate contract. So now coming to the statutory provisions which have to be borne in mind more importantly when we do a real estate contract or when we negotiate on a real estate contract is first and foremost will be 300A. So 300A is you have a right to uh, enjoy and own a property, but that is always subject to a statutory regulations and statutory restrictions. So what are the statutory regulations and what are the statutory regulations is what we are going to see hereafter. Section 5 defines transfer of property, which means it conveys the right of the property to the third party. The meaning of convey may have more than title, and it cannot be always conveyance cannot be always related to the title. So conveyance include any right interest also, and which is evident from the various provisions of law where we have various provisions of sorry, one second. Is it visible now?
Yes, sir.
Sorry. So, which is evident from the various provisions. For example, section 54 deals with sale, section 58 deals with mortgage. And if you see sale and mortgage, sale is transfer of title, mortgage is only transfer of right and interest, which may be enforced against the title. So, but under the document, it is only transfer of right or interest. So this is two contrasting documents or real estate contracts dealt in the provisions of Transfer of Property Act. Again, coming to section 105 lease, there is no transfer of title. It is only transfer of a right of enjoyment of the property. So this three, and of course, exchange and gift will be transfer of title, but the Transfer of Property Act by the whole, with the definitions which I have referred here, would unambiguously will give us an impression that the transfer doesn't refer always to the transfer of title. So that's the most important part we have to mind, because sometimes we cannot be blindfolded to say that, okay, there's no title, I'm protected. So there are various types of rights or interests created. So we need to be very careful on real estate contracts while negotiating, irrespective of whether the title is passed on or not. See, again, at the risk of repetition, Indian Contract Act, see, section 4 of the Transfer of Property Act refers to the Indian Contract Act, and it says all the provisions of Transfer of Property Act is subject to compliance of the incredence of the Indian Contract Act. And the certain provisions of Transfer of Property Act has been made supplemental to Registration Act. So what is concluded from this section 4 is that the Transfer of Property Act is a supplemental or should be read in conjunction with the Indian Contract Act and Registration Act. Certain transactions or certain contracts which are compulsorily registrable and which has to be stamped cannot be relied on or cannot create transfer in favor of any person unless there is compliance of the Registration Act and the incredence of Contract Act. So when I say Registration Act, it has to be registered with the competent registering authorities, because earlier there were certain provisions which permitted to register elsewhere in pan-India basis before the registrars. I'm just giving an example. But now there are certain restrictions which have been amended and which have been brought into amendment in the respective states. So state to state, it may differ. We need to be very careful on the respective jurisdictional registration act and should be aware of the amendments made by their respective states. So that has to be, though Registration Act and Stamp Act are central enactment, but it is within the purview of state governments where they can amend with regard to the Stamp Act. The rates can be amended by the respective state government, or the provisions can be amended with the assent of the president. And the Registration Act similarly can be amended with assent of the president. So we need to be, and that has been done with various states till 2023. We have various amendments to the various states of the States Registration Act. So that needs to be applied. So though the Transfer of Property Act is in a central enactment and universal for the entire India, the section 4 will have to be very carefully dealt with when it comes to the respective states. So the Registration Act and the contract, of course, the Contract Act, there is no state amendments. Registration Act, there are substantial state amendments which we need to take care. Of course, again, Indian Contract Act, proper persons, necessary parties, object of the contract, consideration, and more importantly here, the contract, we should be ensuring that it's not violative of any act. If it is violative of any act, it becomes void. And we also need to be very sure that the circumstances under which a party can disown the contract, which becomes voidable. So this two parts needs to be very carefully, be fully aware of various enactments, various provisions of the local laws, as well as other provisions of the law where like it should not be violating any other provisions of the law where it can be voided at the instance of any breaching party. Is it visible now?
Yes, sir, it's visible.
So sorry, I'll go by. I think there is some issue in the slide show, so I'll
No
go
problem.
by. So there are certain important statutory provisions which provides you the other provisions are like certain provisions which also gives you do's and don'ts of certain acts. For example, section 55 of the Transfer of Property Act clearly enumerates what are the do's of a purchaser and what are the do's of the sellers, and what are when they are protected with regard to their bona fides are certain. So that has to be, that is a process we call as due diligence when we talk about purchasing or contracting with any this thing. The first thing will be with regard to the due diligence of immovable property. So that is something which we need to keep it in mind before entering into a contract, and any finding in the due diligence has to be covered with necessary legal protection in the contract, so that when there is any claim or objections, we are able to enforce it in the contract. So those do's and don'ts we have to be very sure, and to what extent it can be enforced against the counterparty have to be kept in mind. Of course, the Stamp Act is has to be rigorously followed. There is no compromise in Stamp Act. And normally the clients, when we say you have to stamp it for a particular document, they say, I'm not going to register it. Why should I stamp it? So that's the normal mindset of the client. So Stamp Act and Registration Act are entirely two different enactments. The authorities may be same, the enforcing authorities may be the same, but the power of the authorities flows from two different enactments. Stamp Act is a fiscal enactment, which is an indirect tax, and Registration Act is only a regulatory act. So all the amounts collected under the Registration Act is only a fees which is based on the quid pro quo of the service rendered by the authorities, whereas the Stamp Act is an indirect tax. So any violation of Stamp Act will be make the instrument inadmissible. Of course, you have to pay fine and it can be impounded and then make it admissible, but which is a long drawn process. But at the first instance, the admissibility of the document will be put to question. So you have to always have in mind that all the real estate contracts have to be stamped properly with adequate stamping. Then comes the enforceability of a right, interest, or which I was talking about, the difference of in the Limitation Act before regarding the other rights and the rights with regard to the improvable property. Section 27 of the Limitation Act specifically says any right which is not enforced within the period contemplated in the Limitation Act or in any other act which is subject matter, which deals with real estate contracts, if not enforced, it extinguishes the right in the title extinguishes the right in the property. So unlike the other rights, you have, if you are not enforcing your right, section 27 confers the right and interest on the rival party. So it's a transfer by operation of law. That's what I'm trying to explain here. Once you don't enforce within the limitation period, the transfer happens by operation of law to the rival party. And there are certain contracts which is governed by Town and Country Planning Act, which is for example, where I said there are executory contracts to develop the property. Of course, execution of certain things can be done by only a regulatory laws like Town and Country Planning laws, where the development or the construction can be done only by the approved plans. Without approved plans, you cannot start construction, and of course you cannot market without proper registration before RERA. So all this to be kept in mind when it is not between the customer and this thing, but it is between a vendor and the developer or owner of the property, who as the case may be. So that contracts also have to be kept in that certain provisions of law like Town and Country Planning Act, Contract Act are kept in mind. So that those things have to be covered in those laws, in the contracts. So besides the TP Act, there are rights like easement, license. Of course, lease is part of TP Act and governed by rent control laws. Easement and license have their own separate enactment, though provision of section 40 of TP Act provides for a creation of an easement right. But easement and license are covered by a separate enactment called Easement and License Act. And that needs to be governed where there is a servient heritage or dominant heritage. You have to be very careful in fixing those and fixing the liabilities and the term of liability, how there are various types of easement like necessity, grant, etc., custom, etc. So those things you have to be very careful in framing the real estate contract, whether it has attained by a necessity or it has attained by a grant. When there is a grant, there is a transfer of right. So those documents have to be carefully worded and seen in compliance of those provisions of the law. So based on the aforesaid provisions, these taxing statutes also have been, I have categorized these taxing statutes also into three formats. One is taxing statutes, sorry, the real estate contracts have classified into three classifications, which are taxing statutes, regulatory statutes, and enforcing statutes. For example, Stamp Act and Goods and Service Act, or taxes of indirect taxes, which are taxing statute on a particular instrument or a transaction under a particular instrument. When I say instrument, it relates to the real estate contract, real estate matter, and it is a real estate contract. So maybe instrument are outside real estate also, but substantially I'm confining it to real estate contracts. So taxing statutes levy some tax on certain transactions or certain instruments that we need to take care and comply with that. Regulatory statutes are like Registration Act, RERA, Rent Control Laws, and Town and Country Planning Act, where they don't have much on the say. They don't have any impact on the contractual obligations or contractual rights created, but it says the execution part can be done only in a particular manner. For example, Registration Act, you can have a valid sale where Section 54 of TP Act also says that the transfer of title or the sale cannot be made without a registered instrument. So RERA says you cannot sell any product to the customers unless you register you enter into an agreement and register with the RERA. So, and rent control laws for example, as I said, the new law contemplates that unless you register or you with the rent control authorities, a rent control authority is created, then you cannot enforce the lease deed or rent deed, whatever it is. And town and country planning laws is a law where you have to develop only after getting permission from the authorities, and you can't construct without getting permission from the authorities. So these are the enactments which, when you sit on either side for negotiation of real estate contracts, ensure that these provisions are complied with, and unless you comply with it, then the contract will be very difficult to enforce it. And enforcing statute which may not be stricto sensu real estate laws, but it is enforcing the right. For example, when there is a right created under a mortgage deed or a loan agreement, then the enforcement can be executed only under the provisions of these laws. And the General Act has been, to some extent, have been specifically barred under these provisions of the law. So the enforcement has to be done under this law. So when we discuss or negotiate on the mortgage deed or this thing, these provisions of law should be taken care of. So this is again what I have already stated, what are the impacts of the laws, various laws, for example, Stamp Act and Goods and Service Act, statutes like registration. What are the impacts of the various laws? I've already covered this point. And now coming to the effect or impact of RERA. So what are the effect or impact of RERA on the real estate contracts? See, first and foremost, I would like to say RERA is only a regulatory enactment which regulates the rights and obligations of both customers and promoters, and to some extent states or ensures neutrality in the contract between the customer and the promoters. It doesn't much create or substantially affect the rights and obligations which were available under the various other laws. So, and in fact, if you see the provisions of RERA, it substantially saves the local laws and the general rights of the parties. To some extent, it regulates or it restricts this, like for charging of interest, where they have fixed the maximum charging interest, or the time period for which association should be formed, the time period for which the sale deed has to be executed, how the sale deed has to be executed, to whom it has been executed, at what time. So these are the regulations which have come in RERA. But RERA by per se doesn't affect the rights and liabilities created in favor of the customer or the promoters under the general law. So, and the first, and even before RERA came into place, there was one judgment from the Competition Commission of India, which is between Bel Air Owners Association and DLF Limited, where the contracts have been asked to be entered in a particular neutral way. So that's a finding, and based on which there was a Supreme Court ruling, and there was a huge negotiation and change or march of law in the contracts with regard to the real estate contracts between the customer and the promoters. So real estate only makes the penal clauses and the enforcement of the rights under the contract more easy, more approachable, and less time consuming. Otherwise, RERA doesn't have more any obligations or rights created under the RERA for the customer and or the promoter. So this is from my part, and thank you for the wonderful opportunity and patience of hearing me. And Riddhi, any questions you can?
Thank you for the webinar, sir. The session was really appreciative. The floor is open for any questions. So the students, you may raise your hand or you can write your question in the chat box. Meanwhile, sir, I would like to take up the questions which we received earlier. So many of the students ask that what are the career opportunities as a lawyer in real estate? And is it really necessary to have knowledge of real estate while while they appear for any interview of real estate law?
First, I'll just divide the question in two parts. One is what is the scope of the real estate, and second one, what is expected in the interview. First and foremost, see, real estate is definitely related to many transactions. See, for example, even in a M&A or a takeover or a capital, this thing, the real estate, the assets are always called as a real estate transactions, where the due diligence, when even in a M&A or a capital transaction, capital funding transactions, when there is a valuation or when a due diligence of the assets are done, it is a real estate this thing. So if you ask me the scope, real estate is spread over all types of practice, and of course the scope may differ. For example, doing a full-fledged developer, doing a due diligence for full-fledged developer may be a little more deep diving and more meticulous, whereas in a M&A, this thing, what is the risk factor they will look at, it is what will be confined to. So the degree of due diligence may differ, but the real estate practice is spread over or I can say incidental to all kind of practices. A. B, next to understand is that, with regard to the interview questions, for a fresher, we don't expect. For a fresher, we expect only that how potential they are to learn and grow or to grasp things. And of course, we have expectations when there are lateral entries and we look at their background, what much they have learned, all those things. But freshers, we are open to we means in the sense the lawyers or the seniors will always be open that as a fresher we can't expect much more knowledge or experience. So that much we are aware. And of course, now that the exposures are much higher, we will expect to some what extent they will be able to grasp it. To that extent we will see, because now the exposures are more there, where internships are there, other areas of exposures where the students also get to know about the practice. So we will just expect to what extent they can grasp and grow.
Thank you, sir. So the next question is that what are the preventive measures that can be taken before entering into a real estate contract? And also the question allied to this is that what is the difference between normal contract and real estate contract?
See, real estate contract is contract wise, we have to be very careful. See, one is, I think one slide I missed that, just a moment. One second. See, okay, I'll just to tell you, there are parties to the contract, you have to be sure. or the description of the property in a real estate contract. I'm talking about parties to the contract. You have to be very, very sure, and you have to be sure about the obligations and the rights created in the property. The description of the property is more important, because if there is any mistake in the description, it may be ending up in the difficulty in ending up in enforcing the contract, all those things. So these are the things you have to take care of while in a real estate contract. But other other contracts are different in nature, because it depends upon the laws holding the field of that particular contract. So for example, if you take into an M&A, then tax laws, employment laws, all those things will be there. So I can't just like that say you have to take care for other contracts this much. You see, it all depends upon the practice area of which the contract is made.
So the next question, which is relatable to the question I asked, it's the what is the common problem faced in real estate contract, and what kind of cases actually go to court for remedy, and what are the common defense used by the opponents for supporting their contentions?
Sorry, I didn't get your second part of the question.
Okay, sir, I'll repeat the question. The question is, what is the common problem faced in real estate contract, and what kind of cases usually go to court for remedy? Then next question allied to this is what is the common defense used by the opponents for by supporting their contentions?
This is very general question. Like, anyhow, what is the type of disputes? Maybe disputes may be various types, because it all depends upon the conduct of the parties, interpretation of the contract, uh, delay, defaults, breach. All types of disputes may come. So it is very difficult to say that only this type of disputes go for adjudication. And so it's very, very generic, and we can't classify or put it into any different buckets to say that this type only will go for. It all depends upon how the relationship gets tainted and lowered on, where the parties don't come for meeting minds or negotiation between them to resolve the issue. So those times will end up, even if it is a small issue, it may rake up into a litigation, and big issue will get solved by negotiation across the table. So it's very, very generic, which we can't really classify or put it in the buckets.
So the next question is, what kind of work involves real estate practice? How versatile this field is? Please name a few.
Sorry, how?
How versatile the field is.
See, real estate work includes due diligence of title, structuring of the contracts. See, because one transaction may have many incidental supplemental contracts, so it involves structuring of the transaction, taking into other impacts of like direct tax, indirect tax, all those things. Besides that, to protect any claim or interest, or to defend any claim or interest which may be or may not be right claim, or may not be a right. See, it's more on the documentation which will speak before the forums or adjudicating forums to protect your rights. So it is based on that the due diligence will be also lined to or focused to say how much I will be able to defend the title. Structuring of the transaction also will be always, both the parties on the either side will say to what extent they are protected, and they will be uh, willing to be able to little have leverage or breach. So those are the things which need to be uh, forming part of the real estate contract or real estate practice. Of course, there is a litigation practice which is related to real estate, but I'm confining here to the contracts alone.
All right, sir. So the next question for us is that, are there any projects that can be exempted from RERA? And if we are intending to buy a land, should we always check first if it is a RERA authorized?
Of course, there are exemptions which is provided in the law, which is it should be less than 500 square meters or less than 8 apartments, something which is an exempted projects in RERA. And other than that, there's no exception for registration unless it is a completed project before 2017 cutoff date. Yes, when you buy a project from a developer or promoter, definitely you have to look at whether it is registered with RERA. But individual transactions like buying directly from the owner or entering into transaction with the owner for your own use or this thing, which may not be strictly falling within the RERA. RERA includes only the project which is for multiple customers.
Okay. Dear participants, do you have any further questions to ask? So I think there are no more questions. So now to proceed towards the conclusion of the insightful webinar. Firstly, I would like to thank the team of LawInternships for organizing such knowledgeable webinar. Secondly, I would like to thank Mr. G. Vivekanand, sir, for making this webinar a success and enlightening one. Thank you, sir, for sparing your time for this valuable session. Last but not the least, I would like to thank all the participants for joining and staying with us throughout the session. Thank you so much, everyone, for joining with us today.
Thank you.
Thank you so much, sir.
You all.